All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We are here for argument in case number 1 CACV 170069, NICAISE versus SUNDARAM. These proceedings are being audio and video recorded, so we ask the counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Excuse me. Ms. Layton, you are advised that it's your responsibility to reserve any time if you want for rebuttal. We've read the briefs. We've discussed this case in conference. And Ms. Layton, you may proceed.
May it please the Court, Your Honors, good afternoon. I think, and knowing that you've read the briefs, I want to concentrate on issues of law that I think are really worthy of more discussion and clarification. I believe in rereading and analyzing the Court's very lengthy decision, the trial court should have, as a matter of law, considered the best interest attorney's position, which was enumerated in the pretrial statement and during the course of the proceedings. Best interest attorney concluded that father should have had sole legal decision-making. I'm sorry, that father should have had supervised parenting time and the mother should have had sole legal decision-making, and the supervision should have continued until father got his mental health issues under control.
You're confusing me when you say that as a matter of law the court should have considered that. So if you could explain what you're saying, what kind of rule of law are you suggesting that we adopt?
Well, I think if there's the best interest attorney is appointed by the court to be the voice of the child. I think we can all agree on that. And really.
Well, wait. I'm sorry to, and I don't want to distract you from answering that question, but I don't think the best interest attorney is appointed to be the voice of the child. That's a child's attorney. The best interest attorney is appointed to advocate for a viewpoint, but I don't think that is in any way binding on the court.
No, I agree with you, Your Honor. It's not binding, but as a matter of law, I think if the court appoints a best interest attorney, and really, I don't want to disagree with you.
Free to.
I kind of disagree with you, with all due respect, with the utmost respect. It's the best interest attorney for the minor child. So it is the child's, I believe, if you look at, the case law, it is the voice of the little girl in there. He is determining the best interest. I guess you have to ask the best interest of whom or whom. And it would be the best interest. He's looking out for the best interest of the minor child. He's not in there just to have a viewpoint regarding whether he thinks mother or father is correct. Mm-hmm. Is that something that we could agree that might
I really don't want to get you hung up on this smaller point, but a child may have views that are contrary to her best interests.
I agree. It is the father. It's not this isn't a GAL. I agree with you on that. Okay, this is not a GAL. But a child may have views, but a 6-year-old child doesn't. I mean, the court made a finding even that the 6-year-old child was, too young and not verbal enough to really have her own viewpoint. And that's why there is a best interest attorney appointed. And for the court to just, I'm sorry, you wanted to say something?
Well, let me just ask you then, what's the difference for the point you're making? What's the difference between a best interest attorney and a custody evaluator?
I think
the evaluator is a professional whose object is to identify the best interests of the children, right?
Yeah, I think there's a difference. The first of all, the best interest attorney is an advocate. He can go into court, and he's advocating for, and who is he advocating for? He or she. He or she is advocating for the interest of his client, who is the child. And he's advocating for the interest of the child, something that he believes or she believes is in the best interest. So it's the adult voice of the child, if you will.
Counsel, it's just an opinion. It's the lawyer's opinion. And to that extent, the trial court can look at the evidence and has to draw his or her own conclusion about what the evidence shows.
Correct, Your Honor. I agree with you completely on that point. But there were three people in that courtroom. There was the mother's attorney, there was the mother and her attorney, I should say, who was not me. There was the father's attorney, who was not Ms. Callahan, and there was the best interest attorney for the child.
You left out one person, the trier of fact.
Well,
which
yes.
was the judge.
No, I'm talking about the parties. And of course, there was the trier of fact. And then the judge listened to all of these viewpoints. So in the judge's 58-page decision, the trial court did not really mention the best interest attorney at all, except for one time. In a very brief sentence, he said the best interest attorney expressed that both parents are able to raise the child, or words to that effect that we cited in our brief. Did you want to say something?
Well, yeah, that's why I'm confused. And I think I understand, and let me see if I can rephrase your argument a little bit. You started off by saying, as a matter of law, the court should have given more weight to the best interest attorney?
Any weight. He didn't consider.
And I guess it's that you phrase it as a matter of law. Are you asking us to say that the court should defer to the best interest finding?
No, I'm simply, maybe if you want to couch it in terms of abuse of discretion as a matter of law, because when a trial court does not consider or ignores something in the record that should be considered.
Except I'm having a hard time, because how do we know that they didn't consider it?
It's not in the opinion.
Well, so is he supposed to write down every single thing that was presented from start to finish?
Well,
if so, that's the transcript.
Well, okay, but Your Honor, there were pretrial statements filed. So father filed his portion of the pretrial statement through his lawyer, and mother filed her portion, and the best interest attorney filed his portion. And the court, and then father questioned witnesses, the court talked all about that, and mother questioned witnesses, and the court talked all about that, and the best interest attorney questioned witnesses, and the court didn't talk about that at all.
Is there any evidence that was brought out, but crucial evidence that was brought out by the best interest attorney that didn't make the decision in the 50-some-odd pages that Judge Campanola wrote?
Oh, yes, very much so. The best interest attorney.
Give me your best piece of evidence that the best interest lawyer brought out that is not contained in the 56 pages.
That because of father's instability and mental health issues, that he should.
All that evidence is brought out. It's discussed at length by Judge Campanola.
I don't think that Judge Campanola really discussed the IPE in a full and complete way. Judge Campanola, with all due respect to him, I mean, he really tried, and it was a 58-page decision, and I commend him for that. But he didn't bring out really blatant things about the IPE. For instance, the IPE, which I reread in preparation for today, Dr. Akins goes into depth about how the New York Medical Board psychiatrists' analysis of father about that whole issue, and
But
even the
where
fact
does
that he
that
was
take us?
psychotic.
Okay, but where does that take us? Because the court was, I haven't seen a decision where the court was more clear about how keenly aware it was of the difficulties with father. I mean, the court could not have been more clear. So if you add more detail to that, I'm not sure that it takes you anywhere else.
Well, at least he didn't listen, and I want to concentrate on some other issues too, so I'm going to just
Sure.
do a final point on this. But I think the key, in my view anyway, is that the trial judge talked about what mother wanted to happen and why she wanted it to happen. And the trial judge talked about what father wanted to happen and why he wanted to happen and his legal positions. And the best interest attorney had a view that was just about the child. And that's what this whole case was about, the best interest of the child.
But okay, let me then draw you into a different issue.
Okay.
I see the trial court's focus as consistent with the statutory scheme that we have in Arizona. When you say the trial court was concerned with what father wanted to happen and what mother wanted to happen, isn't it the trial court's role to use what they want to what each parent wants to happen as a predictive tool to determine who should then make the decision for the child?
Well, in doing that, one has to ask the question, why was the best interest attorney even there then? If the court wasn't going to give any credence to what that best interest attorney recommended and wasn't even going to put it in his 58-page decision, one wonders why that best interest attorney was participating in this case.
I sense we're going back to an earlier discussion.
Okay.
Just because time is short, let me ask you to address the question that I raised, which is when you look at what parents are likely to do and what they want to have happen, isn't that one of the most crucial pieces of evidence that the trial court needs to consider?
I think that it's crucial, but the parents are advocating for themselves, and even in doing that, I don't think that that's the most crucial thing. I believe that the most crucial thing in a trial court's decision is this court's decision, or maybe it was the Supreme Court on Hayes v. Gama, which was that's the real question at all times. What is in the best interest of the minor child? That is to be the governing over everything.
I think that's a bedrock point.
And so,
go ahead.
Go ahead. No, you go.
If we accept that that's the inquiry, isn't the trial court's real function to ask, what is mother going to decide for this child? What is father going to decide for this child? Can they work together? And if they can't, which of those sets of decisions is more likely to be in the child's best interest?
That's one of the things the court asks. But the other thing that the court asks is, if you give one of these parents final decision-making on something as important as medical issues, and that parent that you're giving final decision-making on has had within his history his license revoked because he was found to be psychotic at one point, and poor decision-making and bad judgment, and his IME that was done.
But if that parent is more likely to pursue treatment and the court concludes the treatment would be in the child's best interest, why isn't that enough to determine?
We're talking about predictors. We're not talking, we had concrete past acts of the father that he was every single thing that was, every single worrisome factor brought out by the New York Board of Medical Examiners that was in evidence and accepted in the trial court, together with the IME of father, really pointed to his bad judgment, his mental health infirmities. his ability to block and threaten and harass every single person in that case.
Wasn't the trial court then had to balance those facts, which the court considered, with the questionable or difficult actions of the mother?
I believe, and I have to save time. It's my biggest problem because I always say I'm going to save it and I don't. But I will leave you just with this because I believe this is another really important issue, and I know that Your Honor was Volk v. Brame you wrote that decision, but I have to tell you that I believe that the court didn't get to hear from mother. The court made these unbelievable, lengthy findings about mother's decisions or the lack thereof, and the court 7 minutes, 8 pages of testimony from mother and 75 pages of testimony from father.
But didn't they have the same amount of time? It's just that where that got
I
allocated?
didn't add it all up, and we tried to, and it was really very difficult to do. But the bottom line is that mother didn't get to say very much at all. She could have answered many of those questions. She believes that her due process was violated by not having, if you go down the judge's...
Counsel, whose fault was that? There were many witnesses called by mother that, in my humble opinion, didn't move the ball forward very much. And those were strategic decisions that were made by trial counsel.
Again, Your Honor, that's a valid point, of course. Had I been sitting in your position, I would say the same thing. But I would also say, going back to Volk v. Brame and Hayes v. Gama, we have to put all that aside.
Okay.
Because we have to talk about the judge being able to hear about the best interest of the child. That's why there is a Hayes v. Gama.
You've asked us to hold that Judge Campanolo violated your client's rights, but after the hearing, when it concluded, did trial counsel say, Judge, we need some more time to allow mother to continue?
The court said
A yes or no answer would be appropriate, probably. Did trial counsel say?
No, he didn't. But he did say, I'm down to 11 minutes, and that was all he was getting, and the judge made that very clear.
Any of the post-trial litigation, did they proffer information as to what the mother would have said that wasn't, they didn't have the opportunity to say?
Yes, we did an attempted motion for new trial, and the court ruled that this court ruled that the trial court didn't have jurisdiction. But in that motion for new trial, we said that the mother would have contested the fact that she didn't take the children to these appointments because she canceled them. She didn't take. A lot of this was done because father blocked it. Father has a blocking illness, if you will, that he just interferes with every single thing that is done, and it's continuing until now. This court has the record up until now, and this court can see everything that happened, and it hasn't changed.
And I'm sorry to interrupt you, but I have just one last quick question that I want to ask you. There's another appeal pending. You filed another notice of appeal.
Yes, there are actually 2 other ones, I think.
Well, we have 2 before us here today. And there's
you're not hearing another oral argument.
Well, we have 2 Superior Court case numbers, one
yeah, they've
appellate
been consolidated,
case.
yes.
But while those were consolidated, I think what we were wondering is whether the other appeal you have is ripe for consolidation into this
case.
No, because
it hasn't been briefed.
Well, the one
It's on attorney's fees, I believe. The
one is on attorney's fees, and the other one is on an unrelated order of protection. So I would have had I could consolidate them, but I would want to be able to do oral argument on those and finish the briefing, because on the attorney's fees, we haven't. And on the...
Understood.
Okay.
Thank you.
Thank you.
Ms. Callahan.
Good afternoon, Your Honors. I'm Carla Callahan for Father Robert NICAISE. As far as the best interest attorney, I'll start out with there, since you had some questions regarding that. My point of view on the best interest attorney and the pretrial statement that he filed was his opinion. It's just the opinion of that person. It's statements, it's not fact. The trier of fact, here's all the evidence. The best interest attorney did not interview even father. So his scope is limited, just like mine is when I represent one party, father. Same with mother's counsel. It's just limited to certain people. So I believe that the court did weigh with the best interest attorney because the best interest attorney did get to question all witnesses, so that helped. That helped the judge find out the evidence in this case, and that's who's supposed to have the evidence, is the judge. Counsel talked about the IEP and the New York Medical Board, and she said that he was claimed psychotic. There is nothing in any record that he was psychotic. He has traits. He has anxiety and adjustment disorder. That's all he had. That was in his psychological evaluation. He's not psychotic. There was never any finding of that. I believe that the 58-page decision it laid out a lot of foundation for anybody reading this opinion. So it was really good. Judge Campanola went in great detail to help everybody understand what was going on, since this was such a huge case and so many professionals were involved in the case. When Judge Campanola, on like page 6 and 31 of his minute entry, actually states that mother has not done the right thing. There was so many times that earlier, prior to trial, the judge asked mother to get certain therapies, or let's even just take the dental. Father did not have anything to do with stepping in and canceling any dental appointments. Mother went to the dental appointments and never sought any treatment. The child needed a tooth pulled. There was 9 cavities, I think there was. She sought no treatment. She just left after 3 appointments. It was months and months that child had to go with cavities and a tooth needing to be extracted. So that is why I think the judge ended up stating my client could have final decision making on medical, because mother sat on her hands and wouldn't do anything. She wasn't vaccinating the child. That was no fault of father's. Mother just didn't do it.
Ms. Callahan, I do have a question on
Okay.
that, if I may. Judge Campanola awarded your client final decision-making as it relates to medical and dental issues, but then went on to give his opinion on, well, not his opinion, ordered specific course for medical and dental. Isn't that inherently inconsistent with an order for final decision-making? Once he made the decision that father should have the final decision-making, aren't those decisions left to father?
Father was advocating for the child to have certain therapies and dental treatment because the child needed this help and the child needed dental work. Father advocated for the child all the time to get...
Which may be a reason to choose father as the decision maker. But when the court then steps in and imposes its own judgment on what decisions father must make, isn't that problematic?
Well, as far as the judge's opinion, but there was other medical professionals' opinion that also stated...
No, I don't mean whether it's a good decision or a bad decision. Is it a decision that the court is entitled to make?
I believe that the court shouldn't make that, but only on the other medical professionals' opinion is how the judge, is the way I interpreted that.
I understand that's the way the judge got there, but unless you are entering the zone of dependency because of parental unfitness, what business is it of the court to say the child shall receive these treatments or these procedures?
I agree that the court should not step in and state exactly that, only just based on the other medical professionals in this case. That's what father was trying to seek, is just help for his child. And
as long as we're on the subject, if we take that same concept to schools, where the court says that the child shall be enrolled in a public school, Is that a decision for the court to make?
No, but not unless two parents are conflicting. One wanted homeschool, one wanted public or private.
Well, let's say that's true. Two parents are conflicting and cannot agree. Is it for the court to decide what school a child goes to? I thought that joint legal or legal decision-making was a concept that applied to parents, and if the parents simply cannot co-parent, then the court picks one parent to make the decision, but the court does not make the decision. Do you disagree with that?
On several cases that I've had, I do. In this particular order on the education, it stated if the two parties cannot agree on which school or the schooling issue, then it would go to mediation. So if you can't mediate it, then we have to go to court. And a judge is going to have to decide since the two parties can't.
Why does a judge have to decide? And where is the legal authority for the judge to decide?
Then I don't know where we would be if...
Well, if you have two married parents, right, and then they just disagree, can they come to court and ask the judge to decide where the child's going to school?
That's what's happening.
Two married parents?
Oh, not married, I'm sorry. In divorcing, yes.
So the government only becomes a super parent when the parents aren't married. I'm struggling to see the legal underpinnings of an order like that.
And specifically the authority for that. I thought the statutory authority was simply the courts decide who decides. It's either going to be joint legal decision-making or final legal decision-making. And so if the parents can't agree on decisions, then obviously they can't be joint legal decision-makers, and so then the court needs to pick one of the parents that he or she believes is going to be make the better choices in the best interest of the child.
And I do agree with that also, Your Honor. But a lot of the minute entries that are coming out now are stating that neither has final decision-making, and you seek mediation, and if mediation doesn't work, then you come back to court.
But that may be a problem, though. And the concept of final decision-making troubles me as well. What is final decision-making? The statute talks about joint or sole. It doesn't talk about interim and final. So do you believe that there is a legal basis for an order that goes into final decision-making as opposed to simply joint or sole?
Well, that would put it back to the question prior to that if somebody doesn't have the final decision-making, then where would we be? We would be in front of the court and asking the judge to decide.
Determine who's going to be the sole legal decision-maker. I mean, the statute simply gives the judge two options, right? The statute says.
Correct.
It's either going to be joint or it's going to be sole.
Correct.
Okay, Judge Campanella picked another option for the medical terms, correct?
Yes.
Where's the statutory authority for that?
It would still be back on if the two parties can't agree on the school, if they have joint, somebody has to be final or mediation or the court.
Or somebody has to be sole, and there's no need for the court, no role for the court, really. If two parents have joint and they can't agree, they don't share decision making jointly with the court. They share it with each other. If they forfeit their joint status by failing to co-parent, isn't the beginning and end of the court's authority to consider which parent receives sole legal decision making?
Yes, and the way I practice on this type of minute entry, when it says that one party has final decision making, I just assume, and I tell some of my clients that technically means sole custody.
Okay.
That's what I tell my clients, and that's what it is, but the court doesn't put it that way in the minute entries.
Okay, so you interpret that to mean sole. Sole. Okay.
I do, but the minute entry does not state that, and I think maybe because it helps ease the parties if it says joint, because the word sole custody to parents means they lost, or that's just the way they feel, that they've lost everything and they're down to sole custody. So maybe that's why the courts are doing joint custody with the final decision making.
I think you're probably fairly describing the culture, but I'm concerned about the law. Has the culture run afoul of the law?
And it probably has.
Okay.
But that is my interpretation. Whenever I read that, I tell my clients, technically it's sole custody.
So the problem I'm having with this order is that Judge Campanola grants what I agree with you is sole legal decision-making as it relates to medical issues, but then nonetheless takes it upon himself to make medical decisions. And I'm not sure what authority he has to do that. Once he's awarded sole legal decision-making to father, isn't that the end of the inquiry? Then it's up to father to make those decisions, not Judge Campanola.
That is true. But it was in line with what father requested or asked for with the medical professionals that were involved in this case. So maybe that's why I wasn't there at the trial, but that could be why the judge did go further and state, go ahead and get these treatments.
Well, that could be, it could be a good finding of fact to say father urges that the child will see or should see professionals A, B, and C for some reasons. I, the court, conclude that that's in the best interest of the child, and therefore I'm giving father sole legal decision-making because he's likely to do that. I think that line of reasoning works. But then to go ahead, and I think it's really the same thing with mother in the school, right? Mother's likely to pursue the type of schooling that I think is in the child's best interest. Therefore, the child's going to go to public school.
Except mother didn't want public school, right? It was father that wanted public
I'm
school.
sorry,
Public-
but the point remains the same, that the choice of school rests with the person who has legal decision-making, not with the court, doesn't it?
It should.
As a matter of law, does it?
It does.
Okay.
It does. And so in this minute entry, the judge may have put extra in or put more on the parents, but the judge was clear that mother wasn't doing what she was even ordered to do. So that's why I believe that he did put more responsibility on father to take care of certain things with the child. But that isn't what mother's complaining about, that the child has to, the judge said you have to go to these therapies, or that isn't what her main crux of her case is. She's just not wanting father to have the final decision making on medical because he lost his medical license. But that, my point on her is she's a medical doctor also, and then she took the child to certain doctors but doesn't inform them of all of the child's medical history.
You'd agree it's at least troubling that your client lost his license under the circumstances in which he lost it. I mean, that's certainly a factor that the trial court was entitled to consider and should consider.
And the trial court did. But his losing his medical license had nothing to do with the child or parenting. It was his practice being a medical doctor, but it had nothing to do with harming children or harming other people. And they weren't psychological evaluators to be able to say what was wrong with him. He ended up with 2 disorders, and it's nothing like what opposing counsel states that is wrong with my client. He just has anxiety and adjustment disorder, in which Judge Campanolo stated in the minute entry that my client was out of control in the beginning of this case. He settled down. And even in the trial, that's when the judge noticed a huge difference. And he started looking at more pieces of this puzzle, because it is a big puzzle. And he found that mother was the one that was obstructing a lot of father's time, parenting time, and it caused father to react. And he admits that it was not good on his part. It wasn't. He admitted it. As far as limiting mom's testimony to 7 minutes, I again would state that was her attorney's. It was the trial prep, could have been allocated different. The times were exactly even. Even the best interest attorney gave up 32 minutes of his time, so that gave each of the parties 16 extra minutes. So mother's attorney could have finished her presentation in that amount of time, because the judge had only ordered 6 hours for the trial and then figured out that it was going to take longer because the judge did take longer in the beginning, and gave the parties an additional 3 hours. Mother's attorney never objected to anything. So therefore, I ask that the Judge Campanolo's decision be upheld at this time.
All right, thank you very much, Ms. Callahan. You know, I'll let you use both of the remaining time since you didn't get into the questions we asked her. Is that all right?
That's fine.
Thank you.
Thank you, Your Honor. I appreciate
Let's
that.
just run them both down to zero.
Well, Your Honors, listening to the dialogue, I must emphasize again, Hobson's choice is what the judge even recognized. Hobson's choice. He said, I can't, this is a case where I can't say that it's in the best interest, I have trouble saying that it's in the best interest to give legal decision-making to either of them. And then he just kind of flips a coin and picks father.
I don't think the judge flipped a coin. With a 58-page minute entry, there's not a lot of coin flipping there. I do think the judge recognized, as many family court judges do from day to day, that there are some difficult cases out there
This is one
with
of them.
few good options.
Yes.
And unless somebody wants to initiate a dependency, what's the family court to do?
Well, Your Honor, I don't believe a dependency is appropriate because I believe my client is a fit mother. But if the judge believed that, the judge had a responsibility to do that. The judge should not have given the equivalent of final decision-making, which was just admitted that Ms. Callahan tells her clients that's really sole legal decision-making. That is not what the judge ordered. The judge ordered that they were to co-parent. And the decision says
Ms. Layton,
mother
do you-
should be consulted.
If the judge makes an order like the Judge Campanola did in this case that says joint legal decision-making with final decision to one parent, isn't that in fact sole legal decision-making?
It's troubling, and that's why we're up here. That's one of the reasons. Because yes, and that's not what the order says, though. Mother should have been consulted. Mother should give her opinion. And then if they can't agree, father, yes, he gets final decision-making, but then mother gets to be a part of that and go to the court and say, he abused his final
That's
decision-making.
a fair summary of what the judge ordered.
But that's not what's happening.
But would you say now, as a matter of law, that what the judge ordered is the functional equivalent of sole legal
Yes,
decision-making?
I think it's an outrage, absolutely.
Okay.
Because mother has been living it. Mother has not been, and you have the index of record up until this very argument. You see what's going on down there. It's the Wild West, Your Honors. I hate to say it.
I
It's
believe
the
it's
Wild
14 pleadings, according to Judge Green, that have been
It's the
filed.
Wild West. The father takes the child in the middle of the night to urgent care centers. Blood tests are given. Shots are given. He won't tell anybody where he's taking the
Just saying,
child.
your time is running out, and I do have a couple of legal questions I'd like to ask
Sure.
you, if I may.
Absolutely.
And it's the same, I'm going to ask you the same question I asked Ms. Callahan, and that is, once a judge imposes what's the functional equivalent of sole legal decision-making, isn't it a mistake, a legal mistake, to then go on and ask or make decisions about the child?
I believe so. And I believe it's kind of the other side of the coin with rubber stamping. That was one of my arguments. It was kind of a backdoor part of one of my arguments where he was rubber stamping. He said, I'm not going to diagnose the child with autism. Nevertheless, I'm going to adopt all of these findings and I'm going to make the decision, and then code it all with a coding on top of it as final decision making for father. Yeah, I think it's an absolute problem. I don't think any judge in family court on this case, probably one of the most complicated and difficult cases, and I've had plenty in my 38-year career. And when I go to the Superior Court and every judge throws up their hands and really they don't know what to do with the case. Mother doesn't know where the child's being taken. Father isn't telling her, probably because father is being told you really have sole legal decision-making. Mother's helpless.
Well, but if father isn't telling her, that's inconsistent with the order and it's inconsistent with the statute.
Yes.
And if father persists in that course, he risks losing that sole legal decision-making.
Nobody's doing anything. Nobody cares. I have filed so many
Wait, hold
motions.
on. That's not an issue before us, and we do have some issues we'd like you to address. And let's say the joint legal decision-making is made.
Yes.
And the parties can't agree on a particular issue. Is the remedy to go back to court to have the court make the decision, or is the remedy to go back to court to have the court decide that one of the two parties is now going to have sole legal
The
decision?
second option is what I believe it has been what I've always been taught and how I practice family law. Absolutely, unless the parties agree on a parenting coordinator, and that's not what happened here.
Okay.
And I just want to say, I just have to correct the record. Yes, psychotic was in the report. Page 8 of the Exhibit 59, Dr. Falke diagnosed Mr. NICAISE with paranoid disorder with psychotic reaction, major depression, recurrent and personality disorder, mixed type with passive-aggressive and narcissistic traits.
But that's not a psychiatric diagnosis. I mean, there is a such thing as a separate psychiatric diagnosis.
That is correct, but that's from another report that was part of his report. And I just wanted to correct that as well.
All right. Thank you very much, Ms. Slayton.
Thank you.
The matter is deemed submitted. We'll issue a decision in due course. Thank you very much.
Thank you.